Good evening, everyone. This is Bhavya Srivastava, Assistant Professor Law, IIMT College of Law, Greater Noida. Today, we'll be having a lecture on Juvenile Justice Act 2015. So, let's talk about highlights, background, features, importance, benefits, issues, and more. So, what is Juvenile Justice Act? The Juvenile Justice Act of 2015 is a law in India that deals with the care and protection of children. It was enacted in 2015 and it replaced the previous Juvenile Justice Act 1986. The act defines a child as a person who is below the age of 18 years. It also defines various categories of children. This includes children in need of care and protection, children in conflict with law, and children in institutional care. Moving on, what are the highlights of Juvenile Justice Act? So, if we talk about the name of the act, then the name of the act is Juvenile Justice Care and Protection of Children Act. The date of passing was 12th of August 2014. However, it was enacted nearly 2 years later, which was 15th of January 2016. The nodal ministry looking after this field is Ministry of Women and Child Development. Now, what is the objective of Juvenile Justice Act? The objective of Juvenile Justice Act is to strengthen and amend the law relating to children who are alleged to be in conflict with the law and children who are in need of care and protection. These two terms, that is, children who are in conflict with law and children who are in need of care and protection, are very important terms because if we move further, then these two will be divided according to various authorities. Children in conflict of law will be dealt by the Juvenile Justice Board. However, children who are in need of care and protection will be dealt by Child Welfare Committee, which we'll be studying in further slides. Now, the Minister of Women and Child Development is Mrs. Smriti Zubin Irani. Now, before moving further, let us first understand what is the background of Juvenile Justice Act. In India, the first law to address children in conflict with law was the Apprentices Act of 1850. This act provides courts with the option of treating children and youth who had committed offences as apprentices rather than locking them up in prison. So, if we talk about crime, then the punishment is usually comprised of imprisonment. So, if we talk about juveniles, then rather than locking up in prison, they were treated differently. The Reformatory Schools Act of 1876 was the second law that dealt with juvenile offenders. Post independence, a lot of things changed. That is, if we talk about 1960 year, then the Children Act was passed to provide care, maintenance, protection, welfare, education, training, trial, and rehabilitation of abused and neglected children. In 1986, the Juvenile Justice Act of 1986 was passed, which established a single set of rules for the entire nation. Now, what was the need of this Juvenile Justice Act? It was a result of United Nations Convention on Rights of the Child. As a result of India's ratification of the treaty, which was named as United Nations Convention on the Rights of Child, it made necessary to have a law that complied with the convention's requirement. However, the Juvenile Justice Act of 1986 was repealed in the year 2000. Finally, the Juvenile Justice Care and Protection Act of Children of 2015 replaced the Juvenile Justice Care and Protection of Children Act 2000. Moving on, let's discuss the salient features of the Juvenile Justice Act 2015. If we talk about the juvenile in terms of age, the Juvenile Justice Act 2015 redefines a juvenile as a person who is below the age of 18 years, in congruence with the CRC. The earlier law defined a juvenile as a person below 16 years. So, the age has been increased by 2 years. It also provides for the rehabilitation of not only victim but also offender through individual care and reintegration. It aims for correction not mere punishment of juvenile offenders. Mandates setting up the child welfare committees for producing of children before it within 24 hours of the apprehension. So if a juvenile offender is taken into custody, then it is become mandatory to produce the child before the juvenile justice board. It enhances protection of the child and also focuses on the speedy trial. Now, it also includes provision of adoption of children both in and out of marriage. It regulates inter-country adoptions. Inter-country adoptions are regulated by CARA, and if we talk about adoption of children, then that has been a distinctive feature of Juvenile Justice Act, which has not been provided anywhere in case of offenders who are juveniles or who are below the age of 18 years. It also stipulates setting up of special homes for rehabilitation of juvenile offenders between 16 to 18 years of age. It also specifies 14 fast-track courts for expeditious disposal of cases related to children. This includes cases of missing children and child victims of abuse. It includes provision for the Central Adoption Resource Authority, as I had taught about CARA, which is Central Adoption Resource Authority. This work to issue no objection certificate for inter-country adoption. There have been various cases where children have been adopted from India and have been sent abroad, but now the authority which is regulating this is Central Adoption Resource Authority. So a no objection certificate is provided by the CARA for inter-country adoption. For every district, at least one institution is set to be set up for giving shelter care to juveniles in crisis. Another salient feature is that it lays down stricter punishments for offences against children. This includes child labor, using children for begging, and sexual offences against children. Moving further, a coin has both sides. So Juvenile Justice Act of 2015 not only has advantages but it also has disadvantages. So firstly, we will be talking about the pros of the Juvenile Justice Act 2015. The Act provides for a separate system of juvenile justice that is different from the adult criminal justice system. Now, if we talk about criminal justice system, then India follows criminal justice system which is adversarial in nature, unlike inquisitorial criminal justice system. Here, the judge gives decision on the basis of evidence and circumstances of the case. Judge is the person who does not investigate, it pronounces judgment on the basis of the evidence and facts of the case. However, apart from India, like in USA, the judgment is based on inquisitorial system where the judge himself or herself conducts inquiry in order to assess the truthfulness of the facts and to ascertain whether the offender is actually guilty or not. So that is the difference between India and other countries as far as the criminal justice system is concerned. So how is the adult criminal justice system different from juvenile justice system is that if the children or if a child commits an offense, then he or she will not be treated like other offenders. He or she will not be kept in jail or prison. He or she will not be taken to police custody to extort confession, or he or she will not be tried in a similar manner as compared to other offenders who are above the age of 18 years. So, what does this mean? This means that children in conflict with the law are not treated as criminals. They are treated as children who need care and protection. Now, what are the safeguards that are provided by this Act? The Act provides various safeguards for children. These safeguards ensure that children are not discriminated against and that their rights are protected. These safeguards include the following. First is the right to a fair trial. Right to a fair trial is a very important right in India, though it is not expressly regarded as a fundamental right, but it forms a part of fundamental right in terms of interpretation. In Senara Khatun, it was held that right to fair trial is very important in criminal justice system. Right to fair trial encompasses two main features, that is audi alteram partem, that is right to be heard, and no man shall be a judge in his own cause. So fair trial ensures equal opportunity of being heard, getting the opportunity to represent oneself, getting the opportunity to know about what are the charges that have been framed against the accused person, and opportunity for him to present his defense. That is also to get a lawyer of his own choice who can defend him in a trial. Now, second right is right to be treated with dignity and respect. It forms a part of Article 21 of the Indian Constitution. Everyone has a right to be treated with dignity and respect, and no one is to be presumed guilty unless there has been a sufficient evidence. So, the criminal justice system of India encompasses this fact that everyone is presumed to be innocent unless proven guilty. So, till the trial is going on, everyone has to be who has been accused of a crime has to be treated with dignity and respect. Now the third right is right to be protected from harm. That if a person is accused of committing a crime, that doesn't mean that the society or the other persons have been granted a free privilege to harm him or to cause any injury to him. So the right to be protected from harm is inbuilt in this justice system, and that is also provided to youthful offenders, that is who are under the age of 18 years. The third right is to right to be protected from harm. To summarize, there are three rights: right to fair trial, right to be treated with dignity and respect, and right to be protected from harm. Now, what other pros which are comprised in this act? They are that one is that the act provides many rehabilitation services for children in conflict with the law. This includes education, vocational training, and counseling. These services help children reintegrate into the society. Supposedly, if a child has been accused of committing a crime and he is said to be then a child in conflict with the law. So, as after the time when he comes out of the home or wherever he has been kept because of as a part of the punishment, then after coming out from there, he needs to establish himself in the society. He needs to make himself a part of the society again. So that might prove difficult for him. So, to ease the same process, he has been provided with education, vocational training, and counseling inside the home, juvenile justice home, so that he can easily reinstate himself within the society after he comes out. So, this is a very important and beneficial legislation because it provides rehabilitation services for children who are in conflict with the law. The Act also provides many care and protection services for children in need of care and protection. This might include foster care, adoption, residential care. So these three are very important because as we say that residence is very important for a person, and apart from residence there are other facilities which are important for the nurture and nourishment of a child. So these include foster care, and if somebody adopts the child who is in need of care and protection, then definitely he can be he can be reformed and he can be easily accommodated and accepted by the society. So if the child is adopted, then that's very good. He can lead a new life. He can also become an asset in the society later on. So these services provide children with a safe and nurturing environment when they can easily grow and develop. Moving on, now, the coin has other side too. So, as we were talking about this, what are the cons of Juvenile Justice Act of 2015? Some people have argued that the act does not go far enough in protecting the rights of children in conflict with the law. They argue that the act should not allow children to be tried as adults, even in cases of serious crimes. So, if a very famous case was there, that is was the Nirbhaya case, which happened on 16 December 2012. In that case, the main offender, who was very brutal, he was of 17 years and some months at the time of committing the crime. So, most of the people argue that he should be tried as an adult instead of a juvenile because the nature of the crime which he committed was very heinous, and it was also argued that he had definitely attained sufficient maturity of understanding that what he is doing is only not contrary to the law but also very heinous and serious, and the consequences would be very disastrous. So there have been various arguments and debates all over the country that if the nature of the crime is such that it is very heinous and it shatters the family of the victim, then definitely he or she should be tried as an adult. But others have also argued that the Act is too lenient on child in conflict with the law. They argue that the Act should provide harsher punishments for children who commit serious crimes. So there has been a debate. Some people say that there needs to be a stricter legislation in terms of children. Some say that the age needs to be reduced. Some say that the punishment needs to be enhanced. So this is still undergoing as a debatable topic. There are also concerns about the implementation of the Act. Some argue that the government has not provided the necessary resources to implement the Act effectively. Moving on, let's talk about the amendments that have happened in the JJ Act, that is Juvenile Justice Act Amendment by Amendment 2021. So recently, the Juvenile Justice Amendment Bill 2021 was passed by the Parliament. Some of the important features of this amendment bill are discussed below. Now, if we talk about serious offenses, there has been a change in the definition of the serious offenses. According to the Amendment Act, if a child is charged with a serious offense, the Juvenile Justice Board will conduct an investigation. Serious offenses are those for which the punishment under the Indian Penal Code, that is IPC, or any other law is imprisonment between 3 to 7 years. So, if we talk about serious offenses, the punishment of which is 3 to 7 years, then the same, that is, the serious offenses has been defined under Section 254 of the Juvenile Justice Amendment Act. I beg your pardon, the same has been defined under 2 Section 45 of the Juvenile Justice Act of 2015. So, serious offenses are those which are punishable with imprisonment ranging between 3 to 7 years. If we talk about IPC now, IPC is also being replaced by the Bharatiya Nyaya Sanhita of 2023, but that is not a matter of discussion as of now. Since Juvenile Justice Amendment Act deals with the IPC only, so we'll be sticking ourselves to that only. So now let's talk about the amendment. According to the amendment, major offences now also include those for which the minimum sentence is either not specified or which is less than 7 years in prison, and maximum sentence is greater than 7 years in prison. Moving further, how are the offenses classified? So, to need a better understanding, let's understand on what basis offenses are classified. So that will be made clear by this amendment. According to this amendment, the offences with imprisonment of more than 7 years shall be cognizable and non-bailable in nature. Now, cognizable offences are those in which the police officer has the authority to arrest a person without warrant. Warrant is something which is given by the magistrate for arrest. So, in cognizable offense, police officer doesn't need to consult magistrate, and he can arrest the offender without warrant. And this offense shall be non-bailable in nature. So, the offenses which are non-bailable in nature, in that a provision of bail is not there, the as a right, that is, offender cannot claim bail as a matter of right. It is on the discretion of the judge to grant bail in case of offenses which are non-bailable in nature. Also, offences punishable with imprisonment between 3 and 7 years shall be of non-cognizable and non-bailable nature. So, these offences being considered less serious in the terms of imprisonment shall be non-cognizable. That is, in this case, police officer needs to first get or obtain a warrant from the concerned magistrate before arresting the offender. So, now, also offences that are punishable with imprisonment less than 3 years shall be of non-cognizable and bailable nature. So, in this case, offender has a right to of the default bail or right to get a bail as a matter of right. So, this was the classification of offences. First being more than 7 years, punishable with more than 7 years. Second being punishable between 3 to 7 years. And third being punishable with imprisonment less than 3 years. So I have already told what are cognizable and non-bailable offences. Some examples can be of rape, murder, etc. A cognizable offence is one that allows the police officer to detain the accused without a warrant and open an inquiry without the magistrate's approval. Examples I had told: rape, murder, etc. In case of non-cognizable offence, that is assault, cheating, etc., police are prohibited from detaining the suspect without a warrant and from opening an inquiry without magistrate's approval. Moving further, what are bailable and non-bailable offences? A bailable offence is one that allows bail as a right, and the arrested accused person must be released after depositing the bail with the police. Some examples of bailable offence are rioting, bribery, etc. Non-bailable offences are serious offences like murder, rape, etc., where bail is a privilege and only the law courts, that is, courts of law, can grant it. Moving further, now there have been a separate courts which are designated for the trial of offences under this act. Normally, the courts which are trying the offences are defined in CRPC, which are usually court of session, judicial magistrate first class, judicial magistrate second class, metropolitan magistrate, etc. However, the courts which are dealing with the offences committed by the children are different. They have been given a different nomenclature. So the designated courts which are there under the provisions of the Juvenile Justice Act 2015 are children's courts. So let's further study. According to the Act, cases involving crimes against children that carry a sentence of more than 7 years in prison will be heard in the Children's Court, which is equivalent to Sessions Court. So, technically Sessions Court would be dealing with the offences. However, it has been named as Children's Court since it will be trying the offence under Juvenile Justice Act, those offences which are punishable with more than 7 years in prison. A judicial magistrate will preside over trials for other offences that carry sentences of less than 7 years in jail. The bill modifies this to state that the Children's Court shall hear cases involving all act violations. So, if we talk about the offense in terms of sentence, then every offense that is punishable with more than 7 years shall be tried by the Children's Court, which is actually a Sessions Court, but which has been named as Children's Court. And remaining offenses, that is residuary offenses, will be presided over by a judicial magistrate. Now, let's further talk about the adoption procedure. In accordance with the Act, an adoption agency must file an application in a civil court to acquire an adoption order as soon as potential adoptive parents accept a child. The Act states that the district magistrate, including extra district magistrates, will perform these duties and issue all such orders in place of the court. So we know there has been a bifurcation in terms of work. Judicial magistrate conducts the trials. However, as far as adoption is concerned, then that power has been granted to the district magistrate. And for that, an adoption agency must file an application in a civil court to obtain an adoption order. Moving on, there is also a provision of appeal which tells that the Act provides that any person who is aggrieved by an adoption order passed by the district magistrate may file an appeal before the divisional commissioner within 30 days of such order. The disposal time of appeal has been told to be 4 weeks, that has to be counted from the date of filing of the appeal. Now let's talk about child welfare committees. According to the Act, each district shall establish one or more child welfare committees to deal with the children who need care and protection. According to the Act, a person will not be able to join the child welfare committee if he has been disqualified on the following grounds, which has that he has been convicted of an offense that involves moral turpitude, he has pending record of violation of human rights or child rights, he has been removed or dismissed from the service of the central government or state government of the country or any other government undertaking, or it is a part of management division of any child care institution in any district. So these are the 4 grounds which act as a disqualification for a person from joining the child welfare committee. To summarize, he should not be a violator of the child rights, he should not be involved in offense involving moral turpitude, he should not be dismissed from the service of central government or state government, and he should not be a part of the child care institution of any district. Moving on, the additional functions which the DM has to perform apart from granting adoption order is supervising the district child protection unit and conducting a quarterly review of the functioning of the child welfare committee. Now let's talk about the removal of members. So, if a member of the committee consistently misses 3 consecutive child welfare committee meetings without good cause or misses less than 3/4 of the meetings in a year, the state government may terminate that person's appointment after conducting an investigation. So this is a disqualification of a person after he has been incorporated in the child welfare committee. Those were that he should not have performed these tasks, but however, if he misses the 3/4 of the meetings in an year, or the government terminates that person's appointment after conducting investigation, then it can act as a ground of removal of that member from the child welfare committee. Moving further, who is a juvenile? So, as we have studied earlier, a juvenile is a child who has not attained the age of 18 years. However, according to Indian laws, as far as Indian Penal Code concerned, then according to Section 82, a child of who is below the age of 7 years cannot be found guilty of the crime. Now, there is a landmark case which is Satyadev versus State of Uttar Pradesh, which was a case of 2020. So, the court held that in light of Section 6 of General Clauses Act, read with Section 25 of the Juvenile Justice Act 2015, an accused cannot be denied of his right to be treated as a juvenile when he was less than 18 years of age at the time of commission of offence, a right which he acquired and has fructified under the 2000 Act, even if the offence was committed prior to the enforcement of 2000 Act, that is on 1st April 2001. So, in terms of Section 25 of the 2015 Act, 2000 Act would continue to apply and govern the proceedings which were pending before the 2015 Act was enforced. So, the main gist of this case is that the person should be below 18 years of age at the time of commission on offence, whether the Act was commenced or not. Moving further, the importance of juvenile justice is great. It is as the future of nation lies in the hands of children, then minorities or under the age of 18 who are accused of any criminal act are typically processed through juvenile justice system. So it also aims to preserve the public safety. It also aims to provide a better life for the offenders who can actually become the future of nation later. There also has been criticism of Juvenile Justice Act by the UN Convention of the Rights of Child Act because people say that it leads to violation of the Child Rights Act and there has been less focus on economic status of society. However, that is not so much of criticism. So let's talk about the way forward. The way forward comprises that district administration should work closely with all the 5 arms, and district magistrate who usually lack knowledge and resources should comply with the specific laws. And there has to be addressing of loopholes in order to ensure rapid delivery of justice. Now, I would like to conclude by saying that in response to the drawbacks of child protection, the Juvenile Justice Care Protection Act 2015 was passed. However, a situation still exists as a result of lack of responsibility, dedication, and coordination between the various child protection partners. So, a single institution should be in charge of the child protection and it should also have a strong, suitable, and effective hierarchical structure that extends all the way down to the village level. So, that was it from my side. Thank you.